الحمد لله رب العالمين والصلاة والسلام على خاتم النبيين والمرسلين سيدنا محمد وعلى آله وصحبه ومن اتبع هداه إلى يوم الدين. من مسجد الأمة إلى من يستمع إلينا أو يرانا من أمة التوحيد، السلام عليكم ورحمة الله تعالى وبركاته. This is the 11th segment dealing more specifically with family in Islam. Last session, the 10th, we only started with just an introductory remark about the dissolution of marriage. I'd love to speak more about engagement and marriage and marital relationship, but we have spent so much time on that already. But while talaq or any form of dissolution of marriage is permissible, but as described in more than one hadith, it is one of the most hated permissible things. For Islam takes a realistic approach toward dissolution of marriage. That is a wasati application, that is an implication of the moderate, or more accurately, just balanced approach of Islam to life. Because on one side, there are those who believe that once marriage is officiated, it can never be resolved, almost never, except in very, very, very exceptional thing like the death of the husband or some other horrible thing. And then there are those who take marriage, which the Quran describes as mithaqan ghalidha, a solemn commitment, very lightly, divorce today, marry tomorrow, and so on. And we indicated that this is not really the Islamic vision of marriage. Actually, the wasati again, the just balance of Islam, is that it realizes that there are certain circumstances, it shouldn't be the rule but the exception, where marital relationship cannot really continue for some reason or the other. There are cases like that, but it is left to the conscience of parties as to whether there is really a justified reason to dissolve that mithaq al-ghalidha, this solemn marital relationship. And this is important also, even like I said, I'd love to keep talking about engagement and marriage and the good things about it. We covered it. But it is essential also for Muslims, including myself, to know what are the rights of husbands and wives in case of dissolution of marriage and its impact also on children. So what we did at the end of the last session, the 10th segment, is basically the meaning of dissolution of marriage, because as we'll see inshallah today, there are a variety of ways. And we spoke also about its hukm, that it could be in some cases almost haram, in some cases almost duty, and in between there might be something detestable or desirable or mubah, or the 5 famous classification of any action in Islam which applies to marriage and divorce and any other topic for that is al-ahkam al-khamsa. Today inshallah we'll catch up from there and begin first by speaking about the Sharia boundaries for whatever is justified to limit, if not prevent, to limit the extent of marriage dissolution. The reference I refer to, I felt might have overlooked one thing that we should begin with, that instead of talking just mechanically about the fiqh rules on justified reasons for marriage's dissolution, I think, in my humble understanding, we should start first to avoid divorce by spousal selection. So it goes even before marriage. And we find various ahadith in which the Prophet ﷺ teaches us that we should be careful who to choose as our future spouse. And that applies, I emphasize, to both. A spouse here means man or woman, husband or wife. Because if that selection is, as best as we try to make it work, is compatible marriage, then inshallah, the extent, I'm not saying that there will be no problem at all or dispute, the extent of spousal disputes can be narrowed down. So beginning with this as number one. The second issue is also for both sides, both spouses, husband and wife, to be considerate, loving, and also patient with one another, not just trying to catch any mistake on the other side or shortcoming, and we all have shortcoming as if we don't have any. So there have to be some patience, forgiveness, and realization that nothing really works perfect, but we try our best. And we actually dealt with that topic before in some more details before coming to this one. The third is to understand that there may be some legitimate reasons where dissolution of marriage or divorce may be reasonably justified. That includes the following. First, divorce is a sort of limitation, narrowing down divorce. The first thing is that the one who divorces must be the husband. You might say, all right, that's a matter of course. Why mention it at all even? No. You know that in some Muslim cultures, unfortunately, especially paternalistic cultures, there are things that are against Sharia that takes place. For example, when the father is not happy with his son's wife, with his daughter-in-law, and he divorced it. I mean, it sounds strange, but I have been told that there are cases of amazing interference on the part of parents or mothers even. A brother tell me that my mother tell me, if you don't divorce your wife, then I will not be happy with you and you have to obey me. But obedience should be, as the Quran and Hadith indicate, no obedience in disobedience of Allah, and no obedience is something that is not fair and reasonable. If a sister's son or the mother's son, in a way, is happy with his wife and there is no good reason for him to divorce her, why pressure him? And again, like I said, it may not be, it may be only few cases, but that is one Sharia requirement. The husband is the one who divorces, not his father, not his mother, or else it's void. But some people may ask, but isn't there some forms in dissolution of marriage in Islam where a wife goes to the judge, and we'll talk about that inshallah later, because of mistreatment or some other reasons, and ask the judge to divorce her? Now he is not the husband. How does that relate to what we just talked about? The answer to that is very simple. Because once a woman goes to the judge and asks for dissolution and give her case, then she's giving this wilaya, guardianship, to the judge. And the judge also, especially Sharia court judge, is an official who is giving also wilaya or guardianship on the part of the government. That's why his divorce would be held valid. Wilaya Shar'iyya, guardianship is. A second restriction also on divorce, that a person, even if he's a husband, if he divorces his wife, for that divorce to be valid, he should be, as the scholars call it, mukallaf, somebody who's capable of carrying the duties and requirements of Islamic practice, which means he should be a major, in other words, not a minor. He should be adult. Allah, you say, all right, but do you mean that a person can get married before he's adult, to add that condition? And there are cases, in fact, that something is known and was known even before Islam, but Islam, put some conditions and regulated it, that they call it khiyar al-bulugh. In other words, technically speaking, you can have a marriage contract, but conditional, even between children. No, it doesn't mean that they become husband and wife. It is almost like in some culture, they say, all right, inshallah, your daughter who's 6 years or 5 years old or something, inshallah, I hope will marry to my son. And both agree to that, whether it's verbal or otherwise. That is not a final divorce. Not a final marriage. It doesn't hold. It is almost like a promise of marriage. Okay? So to regulate that and prevent abuse and give the right to both parties to freely accept the proposed spouse, marriage can only be valid if both of them reaches majority or adulthood, and then they can decide at that time, yes, I accept the agreement between our parents, this is okay for me, and she feels the same way. Only with their free approval would marriage be valid. So this is because, as we mentioned earlier in the series, that one of the prerequisite, not any condition, a prerequisite for validity of marital contract is that both sides freely accept whoever proposes first or arrangement with the family. It is the right of the two parties in engagement, for example, or later in marriage, to freely, without any pressure or compulsion, accept that. One of the conditions also related to being mukallaf, responsible for your deeds, and even if you're adult, they say, for example, if a person divorces his wife while he's sleeping, utter divorce. Obviously, this is not in his conscience. A person who might have some mental issues that he doesn't really fully understand what he or she is doing, also is not, it's a condition for validity of divorce. Some scholars add a person who divorces by mistake. He didn't really mean it. It was some kind of mistake happened, but there was no niyyah or real intention to divorce. A person who forgot something that but more commonly, and unfortunately, at least a viable prohibition here is the person who's under the influence of substance such as alcohol or crack cocaine or whatever, a sakran, because obviously these are something that covers the mind, and that's why the word khamr does not only mean alcohol. Khamr, as Umar radiallahu anhu say, al-khamru ma khamar al-aql. Khamar means ghatta, covered. Anything that covers your mind and your reasoning is regarded as a kind of invalidation of the divorce, of course. And you know that in Canada, within a few days, marijuana would be legalized with some conditions and so on. I believe that this would fall also within something that clouds the mind, but we're not getting in detail in the jurisprudence of intoxication. The other condition, which you see the fuqaha do not leave a gap without trying to cover it, so there will be no, argument, reduce the incidence of divorce. It says that the person must fully understand what he says. For example, if a person doesn't know a word of Arabic, for example, and you ask him, repeat after me, طلقت زوجتي, or to tell his wife, طلقتك. He doesn't know what does that mean in Arabic. It means I divorce you. But he doesn't understand the language. And this is why my humble approach when I officiate marriages between people who do not understand the Arabic language, I either say it in Arabic first and then in English, or just in English, because it is not the matter of Arabic. It is the matter of understanding what you're doing. There is also conditions pertaining to who can be divorced. Of course, as we said earlier, as we said, the person must be the husband. It means also that divorce must be only limited to your own wife. So that's tahsil hasil, just to make sure there's no confusion. But there are other conditions also that are more common, and more questions seem to be raised about that in particular. That a person's utterance of divorce of his wife during her period, I mean the menstruation period, is not valid. And there is no difference that I know of among jurists that this is haram. It is haram. However, whether it becomes effective or not, even though it's haram, there is where difference of opinion. First of all, is there any particular possible reason why talaq or divorce is invalid during that part of the feminine cycle? Allahu A'lam. The hadiths are clear on prohibiting that, but some may argue legitimately that during that particular period, some women or wives are a little bit, touchy, because of the changes that are happening to them physically and otherwise. Their temper might not be. So something might happen from her part that's not really major, and if a person divorces, he also might be missing his wife during that period because the matrimonial intimate relationship is not permitted during that period. So either of them may be in a state which is not permissible for divorce. Likewise, it also prohibits or considering divorce invalid if he divorces his wife in a cycle where she became clear from the bleeding and so on, and he had intimate matrimonial relationship with her. So that is not allowed either. He has to wait until the cycle ends, and then can divorce after that if you want to. So there is ijma' on these 2 points, but like I said, okay, this bid'ah from bid'ah, this bid'ah, the solution is haram. But what happened if a person did that? The majority opinion, and I'm not going to bother you with so much details, but I'll just give you the majority opinion of that. And that includes al-jumhur, like the four madhabs, It is also the opinion adopted by the famous scholar Ibn Taymiyyah, normally called Shaykh al-Islam because of his depth and breadth of knowledge and his enlightened approach, unlike some people who, quote him in a way to justify a very narrow understanding. He was much more enlightened than most people thought. And his famous students also, Ibn al-Qayyim, they adopted that it is not valid. And they have a strong basis from hadith when some Sahabi divorced his wife and during her period and came to the Prophet and said, no, return her and wait until this and that happens. So I think there's a strong justification for that opinion. So it is not valid in that case. So would be void as divorce. Now we come with this itar on this, within that framework of reduction of chances of divorce as much as possible, speak about different forms of marriage dissolution. And just mention them in the beginning because we're bound by time. We have to finish by the time of Isha. So you get the broader picture, so whatever we can finish, inshallah, we can catch up. There is first a woman who's divorced by her husband. Secondly, a woman, so that's called talaq. There is tatliq, which means a woman who's divorced through a court, Sharia court or a Muslim judge. And there are two reasons for that, we'll detail. Thirdly, there is another form of divorce known as khula, or in English the closest term is divestiture, but that's a big word. Anyway, inshallah, we'll come to explain it. When the woman herself asks for divorce or dissolution of her marriage, not because of any problem with the husband in terms of his character, his religiosity, but for some other reasons, inshallah, we'll come to this. That's the third. And the fourth, there is another type that technically is the dissolution of marriage also, but it is quite different. It's called fasakh. The English term for that may be like annulment, to annul something, that the contract was itself void. It was a wrong contract, so that it doesn't meet even as if it didn't happen, but it's wrong. Inshallah, we'll explain each one. Let's begin with the most common one about a woman divorced by her husband. What are her rights? First of all, she has the right of keeping the marital gift, al-mahr. I'm not much happy with the term dowry, that is sometimes dower or dowry, that some people use, because having studied a little bit about and you find that on the internet, by the way, it's called Status of Women in Islam. And in the past, some people, I'm not saying that by way of pointing fingers or anything, that some people used to consider the dower or dowry, quote unquote, the purchase price of woman. There is no such notion at all in the Quran. If you want the exact quotation, just go to the internet, and those who have the access to the research gate for academicians and so on, the full paper is there. So it's not speculation. There are references that consider it as such. In any case, there's nothing called purchase price. A human being is not to be sold or purchased in a variety of forms, but when you come here to marriage is not buying or selling. If some people are doing that, it is totally against what the Quran and Sunnah teach us. what does the Quran say about mahr? وَآتُوا النِّسَاءَ صَدُقَاتِهِنَّ نِحْلَةً. Give women, meaning here your wife to be at the time of marriage or whatever arrangement you have. صَدُقَاتِهِنَّ means their mahr. نِحْلَةً. Nihla means free gift, symbolizing seriousness, symbolizing affection. So it is not a matter of buying and selling. So that's why I say sadaqa, actually. So she will be entitled to keep her mahr that was paid at the time of marriage. But now, there could be other cases, and that's permissible also in Sharia. And we need to specify her full right. For example, somebody says, I'll marry you, and my marital gift is $800. Okay? I'll pay $300 now and $500 later or upon demand. It means it's like a debt in my name. This is known as mu'ajjal, something immediately paid, and the other mu'ajjal, deferred amount. What do you do in that case? In that case, the husband who paid already $300 would be obligated to pay her if he divorces her. It's his initiative. The other, how much? $500, because he promised $800, paid $300, so he has to pay her mu'akhar sadaq, or the deferred part of marital gift. There is a third case. I'm not trying to complicate it, but in this session we'll try to go slightly in more depth than some of the simpler type of coverage of this topic. Sometimes people can get married, and while a person really should pay mahr or promise a mahr to his wife, and by the way, sometimes it is all mu'ajjal. In other words, we say, okay, I'll marry you, my marital gift to you, $800, you accept? I said, fine. Sorry, I'm still looking for work and so on. Do you mind if it becomes a debt in my neck, pay you later or upon demand? That's also permissible. So if he divorces, even though he didn't pay a penny, he has to give them. A fourth case. Suppose a person did not specify the amount of mahr. It doesn't make the marital contract void, by the way. It is not desirable so that you prevent any disputes, but it does not make it void. So you can still have a valid contract. In a case like that, the jurists say that even though he did not specify the amount of marital gift, it should be the marital gift that is common in this culture or that place, and the social status of the families involved. Something that's well known, it ranges between this and that. So some figure through judges, through their own agreement, could be arrived at, even though it was not specified. So that amount also, they call it mahr al-mithl, the marital gift for a person, similar to that divorced wife. So that's the second one. A second right of a divorced woman, again initiation by the husband, that many people seem to not pay much attention to, is known as mut'at al-talaq, that in addition of the mahr that you have to just forgo it, you really need to give her some kind of compensation. It's a kind of consolation also. Divorce is not such a great event that takes place, and Islam gives also a sort of softening hearts measures to that. Mut'at al-talaq. Where does that come from? Let me get you first the ayah. It is the 236th ayah in Surah Al-Baqarah, the second surah. And I'd like to really give the full translation from the most accurate translation I've ever seen of the Quran in English, and that's the one mentioned earlier by Dr. Mustafa Khattab. Okay, 236. Okay. طيب. I'll just recite it in Arabic first. لا جناح عليكم إن طلقتم النساء ما لم تمسوهن أو تفرضوا لهن فريضة ومتعوهن. The word متعوهن, that's for المتعة again. ومتعوهن على الموسع قدره وعلى المقتر قدره متاعا بالمعروف حقا على المحسنين. Let me give you a translation of that part of the ayah first. There is no blame if you divorce women before the marriage is consummated. That's one case, of course. If the marriage is not consummated, or the marital gift is settled, but give them, the translator put between brackets, suitable compensation. Suitable compensation. Doesn't determine what. The rich according to his means, and the poor according to his. A reasonable compensation is an obligation, in his view, translation. He's a faqih also. He's a graduate of Al-Azhar with a PhD. So he is not like any translator, just look in the language. And that's one good advantage of it. A reasonable compensation is an obligation on the doer, on good doers. Okay? So the word mut'ah here is mentioned in the command verb, but we'll clarify a little later. That's not a proof in itself, in a command verb. But this is not the only place, like marriage, for example, that was not consummated, because there is another ayah in the Quran that speaks also about mut'ah, or some reasonable compensation or gift or whatever aside from mahr, even for all women, all divorced women, not only those whose marriage was not consummated yet. And that's in the same surah also, Al-Baqarah, in ayah 241. وَلِلْمُطَلَّقَاتِ مَتَاعٌ بِالْمَعْرُوفِ حَقًّا عَلَى الْمُتَّقِينَ كَذَلِكَ يُبَيِّنُ اللَّهُ لَكُمْ آيَاتِهِ لَعَلَّكُمْ تَعْقِلُونَ. The first of these ayat, in translation, reasonable provision, that's the mut'ah, must be made for divorced women, a duty on those who are mindful of Allah. You notice in the first ayah, it speaks about it is a duty on حَقًّا عَلَى الْمُحْسِنِينَ, on those who do good. And this one, it even goes further. It speaks about all divorced women, عَلَى الْمُتَّقِينَ. It is a duty of those who are mindful of Allah, those who have taqwa. But now, in interpreting this ayat, I'll give you even the opinion that I don't favor, but this is a matter of intellectual honesty. Some people said that this command verb does not necessarily mean that it is a must. Okay? In fact, in the Arabic language, the command verb could refer to something that is a must. Aqimus salah. Nobody will dispute that. Salah is mandatory. Okay? Zakah, siyam, and so on. But it could also sometimes mean something desirable, commendable, but not necessarily mandatory. When the Quran speaks about Qiyamul Layl, for example, especially the one that addressed to the Prophet ﷺ, and other Muslims actually following him, even though the demands on the Prophet was higher because of his status with Allah subhanahu wa ta'ala. So it could be something desirable, Okay? It's not mandatory. It's like Salat al-Sunnah, tasbih, after Salah you say this and that. It could also mean something permissible. Something permissible. Yani, that for example in Hajj you're forbidden from hunting animals, except catching fish, that's exempted. But once you finish the Hajj, the state of consecration, al-ihram, you can, وَإِذَا حَلَلْتُمْ فَاصْطَادُوا in the Quran. But when خلاص you finished and make tahleel, the period of restriction about what you wear and no perfumes and all of that, for Hajj, let's say once you do that, فَاصْطَادُوا. If you take it as a command, imagine 2-3 million Hajjis, if it's a command, once they take off their ihram clothes, they should run around, roam the desert to find something to hunt. And I don't think they will find 300 deer. So obviously it cannot be, even though it's a command verb. But lil jawaz, it means that it is permissible. It is not a must that you have to do. In some cases, even the command verb is made to sort of criticize people, some people, to threaten them of what will happen because of their rejection of Allah subhanahu wa ta'ala. For example, in one ayah in the Quran speaks about them, about those rebellious. اعملوا ما شئتم. Do as you wish. It doesn't mean you should do the evil that you're doing as you wish. It means threaten. Like when you tell someone, okay, do what you want. That means you will see the consequence of your deeds. So forgive me for getting into that. That may appear tangent, but many people are not aware. They say, the Quran said this, the Hadith said. But in what sense? Based on the context and other reasons. Is it a mandatory or is it desirable? And I made that just clear because that is at the root of differing opinion. Some scholars said that this mut'a beyond the mahr or marital gift is there, not that it is a requirement, but it is something desirable or commendable. Okay? Others said no, we take it as lil wujub, that it means you must do that if you are able to. I think, I don't want to be biased one way or the other, but I personally would prefer the second interpretation for a good reason derived from experience here in North America even. I find many people came to me with this case. Example. Somebody married his wife 30, 40 years ago, and he agreed at that time, of course, that used to be equivalent, for example, to a pound was like gold pound at one point. You imagine the value at that time. Or against the dollar, which is the dominant currency in modern world, for example. It was equivalent, for example, to dollar, whether it's rupee or this or that, equivalent to a dollar. Okay? And if that wedding took place, for example, in some place, like today, for example, in India, Pakistan, you find a bunch of rupees would make $1. I don't know what it is now. I think a rupee is almost like 1 cent or something. Am I correct? Something close to that. So he said, okay, I'll give you 1,000 rupees now and 2,000 rupees as delayed marital gift. And after 40 years, even those rupees would be like pennies. And after living with her for 40 years, he tells her that the only thing that is mandatory that all the scholars accept from the ayah, that is the remaining 1,000 rupee that I promised, which means a few cents. And of course, after all that period of marriage, in cases especially when the wife even sacrificed her career, if she had a particular career or skill like a doctor or nurse or whatever, for the sake of her children and her husband. And now she might find it very difficult to find a job. And you tell her, all right, a few cents consolation for you. So this is why, subhanAllah, I find a great wisdom personally in the ayah that says in one place, the one I recited earlier, على الموسع قدر وعلى المقتر قدر. If Allah has given you so much, you don't be too miserly after marriage is dissolved. You see what I mean? So if Allah gave you more, give her more. If this is your means, give according to your means and lift it to the conscience of the individual. And a divorced woman in that case, of course, may have some difficulties, initially at least, even if she's looking for work initially. So there should be something really to help her. And that is something that my understanding, it's not a very wide practice. It should be wide practice, whether it is interpreted as by way of taqwa, fearing Allah and being just, or to be doing good, even though you may not interpret it as mandatory. Now, I think we've gone enough for that, so let's move on to the second form, which is not the solution with the unilateral will of the husband, but actually the woman get divorced by someone else, like through a Sharia court or a justice. When that happens, it happens and is permissible when the matrimonial relationship becomes really almost impossible. It's just too much incompatibility, too much conflict between husband and wife. Of course, the correct way to do it is to ask the husband. Say, she doesn't have to tell you, I hate your guts. I can't stand you. Divorce me. It doesn't have to be. Gently asking for divorce. And it would be nice to do it with mutual understanding. But suppose the husband does not agree, for whatever reason, sometimes to punish his wife, just to be mean, even though he knows that she doesn't want him. All right. In a case like that, when she goes to the judge, it could be under one of two basic, you might say, group of reasons. One, it is known ad-darar, meaning hurt. At-talaq lid-darar. Something is done. It's a broad definition, by the way. It says that كل ما يصدر عن الزوج من قول أو فعل أو ترك دون مبرر شرعي. This is a very valuable statement, because some people think that the darar because he beats her. No, it is more than that. It says darar or hurt is anything that is inflicted by the husband by word, action, or inaction, neglecting a certain duty without any shari'i or reasonable justification. So it could be hurting her physically, hurting her psychologically, for example, through cursing her and cursing her parents and all these kind of things, qadf, accusing her of something she didn't do, and so on. In a case like that, all the judge have to ascertain to make sure that it's not just a rush. And even I understand in Western courts as well, if a woman applies for divorce, it is not uncommon for the judge to ask them to reconsider, to refer them to a counselor, which is truly in the spirit of Islam, really, in that sense. But a question. Suppose a husband left his wife and nobody knows about where the person is located, not heard from him. Can that also be a reason for a woman to ask the judge to divorce her? Now you might think that this is a very unlikely thing, unheard of. I heard of it myself from more than one woman, unfortunately. And let me be very frank. Somebody comes to study in the West, okay? And he go on, he's not married, and he takes a fatwa that has been very severely criticized because it's opposition to all that Islam stands for in terms of honesty and transparency. So he figures out that I could marry a woman, and I especially warn reverts to Islam who enter into Islam, and in the beginning think, oh, alhamdulillah, Muslim husband will help me to practice my deen, and without making a search about the person that may reveal other aspects of his personality. So he comes, and that is deception, and marry her without telling her that he intends, after he finishes his studies, to divorce her and go home. And I'm speaking about a fact that made my heart bleed. A sister who reverted to Islam and was married like that. And everything was normal. He never disclosed any intent. And she had children from him. And one day, after he finished his studies, like the Egyptians say, فَص مَلْحُ وَدَابَ, which is what happened when you have a bunch of salt, put it in the water, disappear. She tried her best to trace him, nowhere. She goes to the embassy of his country of origin. They couldn't help her in any way. How long can she doesn't know. There is no address, no trace. Of course, you find that very strange, but there might be bias also on the part of, some culture. So that's why this is new, but it's old also, and jurists address that issue, which means if a husband is totally lost, nobody knows about where he is, there is time limit. There is time. Even if he did not mean to hurt his wife, somebody lost, maybe he died, maybe he was traveling and was devoured by a tiger, or who knows? How long is she supposed to wait? Well, there is a differing views on that, and I tell you why I am biased towards one particular view. I'm not mentioning even views about the waiting period, because it doesn't make any sense to me, and that's an interpretation. It's not based on the Quran or Sunnah. I read one time those who say, حَتَّى يَمُوتَ أَقْرَانُهُ. She should keep waiting until people of his generation or age are dead. My goodness. Well, suppose, mashallah, Allah gave long life to many of those aqran, because when he was lost, maybe he was 20, 25. Does she have to wait for 90, 99 years if she's still living to remarry? It doesn't make any sense. And like I said, suppose his aqran, people in his age, when he was 25, lived until 75. That's not too much even. 50 years, and after 50 years, who cares to get remarried? But that's an extreme type of view. There is no evidence of that in the Quran. So this is ijtihad. Ijtihad could be right, could be wrong. One has to measure it against the text of Quran and Hadith and the spirit of Islam also. And the concept which is very clear in the sound Hadith of the Prophet ﷺ that applies to all areas. La darara wa la darar. One should not hurt or harm himself or harm others. But the most common, one of the common opinions for that is that she can wait for 4 years. Quite frankly, I favor the opinion that says 6 months. And that is the opinion of Ahmad ibn Hanbal, one of the major leaders of major schools of jurisprudence. How about if the person is away because he is jailed, for example? And the jail sentence could be maybe 20 years, 25 years. If you're in Egypt, it could be 127 years of jail, multiple rulings against. How long can she stay? I was very glad to read that in some Muslim countries, if the person who's in prison have wealth that the wife can, live on, inshallah, we'll finish very quick. Then they could arrange for conjugal visits, that his wife can visit him in jail for, in a privacy that would enable them both to satisfy their needs. So that might reduce the suffering of both. So I'll just try to stop at this time, and inshallah next week we'll continue with that. The question of khul, when the woman herself initiates the solution of marriage, and also annulment. I think we reached the time now for Isha. طيب جزاكم الله خيرا, and see you next week in أحيان الله if Allah سبحانه وتعالى wills. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين وصلى اللهم على النبي محمد وعلى آله وصحبه أجمعين. والسلام عليكم ورحمة الله.
الله أكبر الله أكبر الله